It's becoming increasingly clear that Rupert Murdoch and the MPAA and those who are mad about the huge opposition that SOPA has been getting are just upset that they don't have complete 100% control of the media yet. Shit goes on the internet that exposes Fox's bullshit and Rupert Murdoch can't stand it. They want this bill to go through because it effectively allows companies to shut down any website they want by vaguely deeming it to be a site dedicated to theft of US property. And the site basically can't go back up until the site's owners can prove that that is not the case. I found this fantastic article by the Harvard Law professor Lawrence H. Tribe about the various ways in which SOPA violates the First Amendment of the Constitution. I'll put a link to that in the description. Tribe argues that since SOPA switches the burden of enforcement to the website and allows any company that makes a complaint to have advertising and online payment services removed before the defendant even has a chance to defend himself in court, this amounts to what is called prior restraint. Prior restraint is keeping someone from publishing information until the publisher can prove that what they are publishing does not violate the laws against defamation or, in this case, copyright infringement. Constitutionally, prior restraint is not allowed. If somebody publishes something defamatory against you, you could take them to court for it after the fact, but you cannot use the state to preemptively keep them from saying what they intend to say. Under the current copyright system, if somebody posts something copyrighted to a website, that site can be sued by the copyright owner to have the material taken down and/or compensation paid. Under SOPA, a site's revenue can be cut off under the mere accusation that something on that site infringes copyright, and it is up to the defendant to prove that those accusations are incorrect. Rather than a site being taken down after the site's owners are taken to court and given a fair trial, SOPA allows a site to be shut down before a trial ever takes place. In the case of Friedman v. Maryland, the Supreme Court said, "Only a judicial determination in an adversary proceeding ensures the necessary sensitivity to freedom of expression, and only a procedure requiring a judicial determination suffices to impose a valid final restraint." The Supreme Court has also ruled that intimidation or chilling effects are also unconstitutional. In the case of Bantam Books v. Sullivan, the state of Rhode Island sent a list of books they deemed objectionable around to local bookstores. The list was informal and it didn't threaten any kind of legal action or anything like that. It was just a list of books that the government of Rhode Island didn't like. But the Supreme Court ruled that even that was unconstitutional. The government is not even allowed to intimidate people out of saying what they want to say. Given the very broad and vague language about what constitutes a site dedicated to theft of US property, sites like Facebook or Wikipedia are going to have to severely restrict even legal speech on their sites, just to be sure that nothing that violates this law sneaks on there. The court argued in an analogous case, Virginia v. Hicks, that many persons, rather than undertake the considerable burden, and sometimes risk, of vindicating their rights through case-by-case litigation, will choose simply to abstain from protected speech, harming not only themselves but society as a whole, which is deprived of an uninhibited marketplace of ideas. There is little doubt among anyone that in order to protect themselves from litigation, websites will end up curtailing perfectly legal speech in their attempts to prevent potential copyright infringement. For instance, if you upload a video with copyrighted but fair use clips from somebody else's video, YouTube isn't going to go to court to defend your ass. They're just going to take it down, whether it's fair use or not. If SOPA ever went through, you could kiss fair use on YouTube goodbye. It would be gone. You might have to kiss YouTube goodbye, because the burden that this law places on websites like this may mean that a video couldn't even be shown until it was approved by a moderator, which with a site like this would make YouTube altogether unworkable. This is why among the branches of government, only the judicial system has the ability and legitimate power to deem a particular publication unprotected by the First Amendment. Look at how the DMCA is abused right now. Nobody could credibly argue that the DMCA is not used to censor people, but even the DMCA can only get individual videos taken down. SOPA makes it possible to block access to whole websites for one infringement, even if the rest of the site is perfectly legitimate. And here's the really fucked up part. The person filing the complaint does not even have to be the copyright owner. Anyone can send a notice like this to an advertiser or a payment processor to stop dealing with the website in question, whether they own the copyright that's being infringed upon or not. The potential for this to be abused is staggering.